Good afternoon, welcome to this webinar. It's the latest in a series of our occasional webinars brought to you by Town and Town Legal and Landmark Chambers. Today's session is all about the latest permitted development right that's just been introduced by the government. I say the latest because, as we know from last year, someone's just said thank you for, well done for unmuting yourself. Excellent. It was always a good start, isn't it? Yeah, as we know, from last year, the government decided that PDRs are to be indistinguishable from buses, and the latest vehicle for a PDR comes in the form of these small but perfectly formed, relatively speaking, that is, when we compare it with what we got last year, which was pages and pages of PDRs, the new Class MA, and that enables new dwellings to be created again, but by way of a change of use from Class E, which is the commercial, business and service class, which is also a pretty new invention itself from last year, to use as dwelling houses. So that tells you what we're going to talk about, and we have reprised the brilliant and learned panel from our last PDR session, which was at the end of last year, to help us understand what this new PDR is. What the main issues are, what uncertainties there are, and so I'm now going to introduce them to you. We've got Simon Ricketts, brilliant fellow partner at Town Legal. Most importantly, Simon's had a post-lockdown haircut. Say hello with your new haircut.
Hi. Well, you said no frills in the title to the thing, so I got rid of my frills.
Yes, and there were a few. Moving on to Zack. Simon's from Landmark, fresh out of the virtual door of an inquiry, straight through the virtual door of this webinar. I believe you're now known as the Prince of Planorax.
That's right. Thank you, Duncan, for that. Yeah.
Yeah, exactly.
I'm going to print that on a hat, I think. But yes, good evening, Meeta.
More importantly, you've had a post-lockdown haircut?
Well, it was one, but it's one that I actually administered myself. So, I'm not very proud of it. I need the hand of a professional as soon as humanly possible.
I promise I would not say anything about that and just leave it there. So and saving the best till last. I described her last time as brilliant and quirky and brilliantly quirky, and that still holds. Victoria McKeegan, Senior Associate at Town Legal. Again, most importantly, Victoria, you've also had a post-lockdown haircut. Say hello, Victoria.
Hello, Meeta. Hello, everybody.
And to finish off introductions, I'm your chair, Meeta Kaur, also a partner at Town Legal. No post-lockdown haircut at all. I can only apologise. A few housekeeping points to note. Your microphones are automatically muted. You will not need to adjust your own settings. We very much welcome questions, so please submit them in the Q&A section, which is somewhere on your screen. Someone better than me will probably be able to identify exactly where. We'll try to get to as many as possible, but thank you to those of you who have sent us some homework ahead of the webinar. We'll definitely get to some of your questions later on in the session. Apologies if we don't get to all of them. If your connection is lost at any point during the webinar, you can just rejoin the meeting by going back to the original link. So, time to get on with the session. As per usual, we've only got an hour. So what's going to happen now is I'm going to tell you what we're going to say, then we're going to say it, answer some questions, and then we're going to summarise what we've said. So what are we going to say? Victoria is going to kick us off with a nuts and bolts introduction of Class MA. It's going to include not only what's coming in, but also what's out of fashion now, and also a bit of discussion around the consultation that preceded the PDR, as well as the PDR itself. Then Zack, you're going to cover some areas of uncertainty or some tricky bits that you've identified. And being of a sort of troublemaker-ish mind, I think you've managed to find a few. And then Simon is going to cover potential strategies to optimise benefits, as well as looking at things like the Article 4 position. So on that basis, I think I better hand over as quickly as I can to you, Victoria, so that you can give us the proverbial nuts and bolts bit.
Super, thanks, Meeta. So Class MA. Do you need a master's from Harvard MA and a mega annum to comprehend it? Is it the ma of all PD rights? I looked to the periodic table for inspiration, but MA didn't feature. Na, sodium, comes close, but this is more spice than salt. Or is it? You could say the spice was in the consultation. That hit on the day of this group's last PD rights webinar. One of our party described the proposals as the most radical planning reform of the year. Would he say so now? Maybe he'll tell us. In any event, the upshot of the consultation was MA, not mission abort. So what are we talking about here? A Class E, a Class MA? We're talking about a new PD right, a new Class MA in the General Permitted Development Order, GPDO, to allow changes of use from Class E, introduced in September last year, to Class C3 residential. MA may not be in the periodic table, but it's the product of E equals C3, and the explosion happens on the 1st of August 2021. So far, so consultation. The fundamental principle remains, this new enshrined right, but it's not what it was. Consultation has changed it, and as the cogs of government have turned, liberties have been curtailed. So let's adopt that popular internet meme, which seeks to compare and contrast how it, meaning something, started, versus how it's going, or has gone in this case. How did that even start? How it started, meaning how it started life in the government's December consultation. How it's gone, meaning how it's ended up in the legislation. How it started then. Building on the delivery of the PD right for the change of use from office to residential, it is proposed that there be no size limit. No size limit. How it's gone. No more than 1,500 square metres of floor space in any building may change use. This is, so the government says, to focus the right on medium-sized high street sites, which are more likely to be suitable for conversion. Note that the size limit is referable to the floor space subject to conversion and not to the building per se. I'll discuss this further in the context of partial conversion. How it started. In order to benefit from the right, premises must have been in Class E on the 1st of September 2020, when the new use class came into effect. Is that all? How it's gone. In order to prevent gaming, who said planning is a game? The building must have been in Class E for 2 years before benefiting from the right. This includes time spent in the former uses now comprising Class E. The legislation doesn't specify that the use or mix of uses needs to have been the same during that 2-year period. It must simply have been in one or more such uses for a continuous period of at least 2 years prior to the date of the application for prior approval. How it started. This right would allow, for example, for the building or part of the building to change use rather than lying vacant, for example. For example, how it's gone. To protect successful businesses, this right will require the building to have been vacant for 3 continuous months immediately before the date of the application for prior approval. COVID-related closures don't count towards this, according to the explanatory memorandum, where the building continues to be occupied by the owner or tenant. The legislation carries forward the ability to effect a change of use of only part of the building, with the explanatory memorandum citing the example of where, for instance, the lower floors are in Class E and the upper floors are residential. Importantly, for the purposes of Class MA, the definition of building includes part of a building. This ties in with the 1,500 square metre floor space limit, i.e. you don't need to convert the entire building. Further, for the purposes of the vacancy test, while the legislation refers to the building having been vacant for 3 months, this should be taken to refer to just the floor space subject to the conversion. It would also only be this floor space which needs to have been in Class E for 2 years before benefiting from the right. How it started. While the right would not apply in other sensitive Article 2.3 land, such as national parks and AONBs, it would apply in conservation areas. How it's gone. The same, but as trailed in the consultation, the impact of the loss of ground floor Class E use on the character and sustainability of the conservation area will be a matter of prior approval. How it started. Prior approval will cover the following matters: flooding, transport, contamination, the impacts of noise from existing commercial premises on the intended occupiers of the development, the provision of adequate natural light in all habitable rooms, fire safety and the impacts on the intended occupiers of introducing a residential use in an area the authority considers is important for heavy industry, waste management, and storage and distribution, or a mix. Lovely spot for a home, that. How it's gone. Yes to all other than fire safety, which is currently extinguished, but which will be reignited later in the year via separate legislation. And add one more, the impact of the loss of health centres and registered children's nurseries on the provision of local services. So those are the key facets of this new right and some key distinguishing features between how it started life in the December consultation and how it has reached maturity in the amendment order. But that's not the only comparison it's worth undertaking. Let's also think about what this new fundamental right is replacing. Class O, no more. The last date for making a prior approval application under the existing Class O Office to Residential PD right is the 31st of July this year. Class M, amen to that. Well, at least in part. The last date for making a prior approval application under Class M, retail, takeaways and certain sui generis uses to residential, where the change of use is from a building in Class A1 or A2 use, i.e. the uses subject to Class M, which now fall within Class E and which will be able to benefit from Class MA, is the 31st of July. Class M will still at present apply to certain uses, e.g. takeaways, betting offices, payday loan shops, but the government signalled in the December consultation that it would amend PD rights of this nature, given that, for instance, Class A5 takeaways is now obsolete. Under the transitional arrangements in connection with the introduction of Class E, 31st of July this year is the end date for which use classes in force up until the 31st of August 2020, i.e. the pre-Class E use classes, continue to have effect under the GPDO, hence the need to tidy up PD rights by the 1st of August. And so what's the difference between these existing PD rights and the new Class MA? Well, for Class O, Office to Resi, there was no floor space limit, no vacancy requirement. It could be exercised in all Article 2.3 land, not just conservation areas, but AONBs, SSSIs, etc. And prior approval rights were marginally more limited. Further and uniquely, Class O allowed the dwellings created to keep their own PD rights, and that's no longer the case. Neither MA nor O apply to listed buildings or curtilage development, and neither permit any operational development. For Class M, there was a smaller floor space limit of 150 square metres. The right didn't apply in any Article 2.3 land, not even conservation areas. There was no vacancy requirement, and building operations reasonably necessary were permitted in connection with the change of use. But Class M did include a prior approval matter considering the impact of the loss of retail, which isn't carried forward into Class MA, and Zack's going to touch on that shortly. It's also worth noting that there are a number of uses now forming part of Class E, which didn't previously benefit from the ability to change to residential via PD rights, namely uses that formerly fell within Class C3 and the various D use classes which now fall within Class E. For completeness, it's also worth noting that Class PA, light industrial to residential, expired on the 30th of September 2020, hence the reason for not covering this, given that Class B1 does of course now form part of Class E. As a footnote to the above, the requirement to meet space standards for any dwelling houses created by way of PD rights came into force on the 6th of April. And so that applies to classes O and M at present, but will also apply to the new Class MA. Also, there's the common requirement within PD rights that development must be completed within 3 years of the prior approval date. So, swings and roundabouts, winners and losers. Overall, on balance, all things considered, the new rights represent a paring back of what some would term the Wild West of Office to Resi PD. On the other hand, they increase the scope of retail to Resi PD and share the PD spoils with more town centre commercial uses. With the floor space limit, the beneficiaries are likely to be the owners and developers of small buildings, as the conversion of the entirety of large or even medium-sized office blocks and department stores will not be covered, and the feasibility of their partial conversion is perhaps more questionable. Another little quirk is SIL. There is no exemption from SIL for permitted development, but usually the in-use building exemption will apply if at least part of the building has been occupied for a lawful use for at least 6 months continuously in the last 3 years. But didn't we say that the building had to be vacant? Yes, that is true. So the SIL exemption is still doable, but just be careful. So let me end on the slogan for the state of MA, make it yours, but tell others. For the first time, there's a requirement to notify adjoining owners and occupiers of what you're up to, which will apply to all prior approval applications under Part 3 of the GPDO. Class MA has been sanitised, but wears no mask. Thank you.
Brilliant. Thank you, Victoria. Brilliant as always. Really excellent. I think that's really sort of firmly put us in the frame and oriented us on the main subject matter. And I think already that it's apparent to us where some of the tricky areas are going to be. However, Zack, can you now take us through some of those trickier bits that you've identified? And I think you're going to cover issues around prior approval.
Yeah, I will try, but there's no way I can match Victoria for jokes per word. No way at all. But I'll have a go. Now, if you actually intend to avail yourselves of this new permitted development right, you're going to need prior approval. We have touched on this in 1 or 2 previous webinars, but just a couple of quick headlines to make sure that we're all on the same page. Now, firstly, just to start at the very beginning, prior approval applications are not planning applications. Permission's already been granted. It's been granted by the development order itself, by the GPDO. A prior approval application is effectively an application to discharge conditions pertaining to that permitted development right. So the point is, we don't go back to section 38(6) of the Planning and Compulsory Purchase Act. The scope of the issues material to our prior approval application is fixed, and it is fixed exclusively by the terms of the order. There's no freestanding requirement to think about the development plan or other material considerations more generally, or even the MPPF, unless, of course, the order tells us to think about the MPPF, and I'll come back to that in a few minutes. So, what issues will be relevant for a prior approval application under Class MA, and which won't be? Let's start then with the issues that you will have to consider. Now, it's a relatively chunky list. There are 8 points on it. I won't read them all out for you, but there's a few things to say about the list. The first thing is that it is quite long. It gives rise, as I'll show you in a moment, to a few issues. It's not a blank check. Applicants have some work to do, even with a fair wind, and that's even before we get to other interesting issues like national space standards or vacancy, something that Victoria touched on. This list of conditions is considerably longer than the list of points that you've got to cover for existing Class O applications, where the prior approval requirements only cover highways, contamination and flooding. We've got a lot more to deal with here. The extra issues on the list, over and above Class O issues, raise difficult questions, and they are not questions which the order itself gives us answers to. And I will give you 3 examples of what I'm talking about. The first is the provision of adequate natural light. Now, what does that mean? We don't know. Normally, whether there's adequate natural light or not in a habitable room is a matter of judgment in the end, under the auspices of amenity policies in a local plan. Well, now it's a question of law, which means it's got to have a correct legal answer, but heavens knows how we actually go about working out what the answer is. In practice, the standard text is normally the Paul Littlefair BRE guidance, site layout planning for daylight and sunlight, but that guidance tells us in terms that it's not mandatory, should be interpreted flexibly, and should not be seen as an instrument of planning policy, still less some sort of crib sheet for determining legal compliance. So adequate natural light in habitable rooms, there's your first murky issue. The second, I'll read this out for you. We've got to consider the impact on intended occupiers of the development of the introduction of residential use in an area the authority considers to be important for general or heavy industry, waste management, storage and distribution, or a mix of such uses. Now, what does that mean? What kind of impacts are we actually supposed to be worried about with respect to that condition? We're told that the condition was introduced as a result of comments received about the impact on residents from unsuitable locations. But what kind of impacts? Unsuitable, in what way? Does the impacts on, quote, intended occupiers suggest that we're interested in residential amenity here? Is that what we're after? And if so, amenity of what stripe? It can't be noise because we've got a condition that deals with noise specifically already. Ditto natural light, of course, as I've just said. So what kind of topics are we actually supposed to address to satisfy this condition in a prior approval application? Again, you know, the order doesn't tell us. And once we know what kind of impacts we're interested in for the purposes of this condition, then how does a council decide which areas are quote unquote important for heavy industry? Does that just mean allocated sites? What does it mean? How do we find out what their decisions on this topic are? Are they entitled to just sort of, you know, make it up as they go along, if you like, and decide on an ad hoc application by application basis whether or not a particular area is important? And if in the end there ends up being a lot of legal uncertainty about all of the things that I've just been running through, and if that uncertainty leads to lots of refusals over things like, for example, is a particular area indeed an important area for general industry or whatever, is that in fact going to limit the take-up of this permitted development right, so that it won't have quite the scale of benefit of delivering lots of new houses, which the ministry is hoping for? Well, time will tell. That was the second of my murky areas. And the third one is about conservation areas. The third is, if you're developing the ground floor of a building in a conservation area, you've got to consider the impact of that change of use on the character or the sustainability of the conservation area. Now, on character, okay, you may think, certainly there will be cases where the historic interest of a conservation area has something or other to do with a commercial or a retail environment of some kind. I'm sure we can all think of examples. But it doesn't stop at character. We've also got to consider the sustainability of the conservation area. And we should take a step back here. When the first framework was introduced in 2012, there were extensive debates at that time in Parliament about whether or not it should contain a proper once and for all definition of sustainable development. And in the end, the government said, no, you'll know it when you see it. We'll set out some overarching themes for what it covers in the framework, and we'll leave it to individual plan makers and decision takers to form their own judgments. Fair enough, you might think, so far as policy drafting is concerned. Lots of planning policy uses high-level language and leaves it to decision makers or plan makers to apply it to a given case or in a given area. Okay, but again, this is not policy. This is law. And that matters because all of the court judgments in the last few years, and there have been lots, which have emphasised that the courts will normally take a pretty deferential approach to decision makers on questions of the application of planning policy. Well, law's a different issue. Legal language and legislation is for the court to define, to interpret, and sometimes to apply. So, what do the draftsmen of Class MA actually mean when they talk about the sustainability of a conservation area? And remember, conservation areas are designated not because of any particular degree of sustainability, whatever that means, but because of their special architectural or historic interest. Maybe, sometimes, changing a commercial use to residential could impact that significance. Fine, okay, but even if it did, what's that got to do with sustainability? Well, I mean, I think there's real scope for argument on what that word sustainability is doing in this condition. And what you've got to do in order to satisfy it if you're applying for prior approval. What are the legal criteria for something being sustainable, for a conservation area being sustainable? The government's never been bold enough to try and answer that question. They still haven't in Class MA, so we've got to try and answer it case by case. And all of that gives rise to the same question again. If this lack of clarity leads to refusals, uncertainties, the risk is that the new right won't be as effective in delivering new homes as the government hopes. And those are some of the areas that your prior approval application will have to cover. And I thought I'd just end with touching on a couple of things that it won't have to cover. As I alluded to a few minutes ago, this is not a Section 38(6) exercise. Policies, local plan policies, neighbourhood plan policies are literally beside the point. Now, here, under the prior approval procedure, the local planning authority has to have regard to the National Planning Policy Framework as a consequence of paragraph W. It's got to have regard to the National Planning Policy Framework so far as relevant to the subject matter of the prior approval as if the application were a planning application. That's the caveat. There is this sort of way in for the NPPF to have a role in shaping prior approval applications. But I think what that actually means in the context of Class MA is actually really complicated, difficult conceptually. What it doesn't mean is that we somehow throw open things like the sequential test in respect of retail applications or town centre uses, or any impact test in relation to the loss of retail or whatever kind of use it is on the vitality or viability of the town centre. And the reason that I say that we're not going there or anywhere near there is because those issues are very likely, I think, to be well outside the, quote, subject matter of the prior approval. So those bits of the MPPF are not engaged. All of this doesn't square easily with the decades of government policy which have supported their town centre first agenda. Of course, we've still got those policies in the framework and in the PPG. The difference is, as I say, that in prior approval applications, unlike in planning applications, those policies won't be activated, and nor the policies about building beautiful, because we are, and I'll come back to this in a moment, only talking about changes of use, not operational development, or broader policies about sustainable locations for new housing. It does, I think, give rise to an interesting question about what the future actually is for planning in town centres and how that's going to work. Does it indeed have much of a future? And here, perhaps, and this is just the last thing I wanted to say, it might just be worth reflecting on what Class MA is actually about. Victoria alluded to this a few minutes ago. Class MA is about changes of use. It's not about operational development. So if you need a new building, if you need to change or extend or amend an existing building in a way which isn't itself permitted development, and you very often will in order to convert commercial buildings into an appropriate residential space, well, you're going to need an old-fashioned planning application. And town centre policies in a local plan, and indeed in the MPPF, could be really important factors then when it comes to finding a planning basis for imposing conditions to limit uses to, say, retail or whatever it is. The PPG tells us that conditions for restricting the future use of permitted development rights or changes of use may not pass the test of reasonableness or necessity. May not. Whether they will or will not in a given case depends. And one of the things it depends on is what the planning policy framework is in your area in respect of town centre uses and what those policies say. So is there any point left in continuing to plan for town centres? I think there is. On the other hand, I think we should be clear about what Class MA brings about. And what it really brings about is a purposeful frustration by the ministry on the ability to plan for town centre uses. That's not a bug, that's a feature, that's the whole point. It's a feature because the government wants to focus on flexibility in town centres, and that by definition is something that can't be planned. And I think when you take Class E and Class MA together, where we're left is a considerably more modest, still important, but more modest role of the planning system in its ability to regulate the uses which come forward in town centres. That's it from me, Meeta. Back to you.
Brilliant. Thanks, Zach. That's really useful. I think that we will most likely be coming back around to some of those issues a bit later on, particularly when we get to the Q&A. But for the moment, turning to you, Simon, you're going to cover some points around strategies that you could employ around some of these issues that might arise, particularly if you're someone exploring perhaps whether Class MA is something that you might be able to benefit from.
Yeah, absolutely. And first off, thanks Victoria and Zach, both brilliant. And I'd give a plug for Zach's blog post this morning, which is really great on town centres. I'm putting myself in the shoes of myself, actually, frequently run by private sector clients who want to understand and possibly take advantage of permitted development rights as part of their overall strategy. And I've got a collection of thoughts which I thought I'd share with you. And the first one is, they're probably all obvious. The first one is obvious, which is, first of all, you need to make sure that your use fits within Class E in the first place, because as we heard from Victoria, the use of the building must have fallen within one or more of the use the classes specified in Class E for a continuous period of at least 2 years prior to the date of the prior approval application. Often that will be obvious, but often it won't. And often you'll be needing to think about whether you need to do something to form so that you have the evidence to support your the basis for your application. For example, if there's a doubt as to whether your building is in light industrial use rather than general industrial, or whether it's light industrial versus storage, these things are often quite difficult to ascertain, or there are arguments. Whether you've got a retail use versus the new F2 local community use, again, you may need to think about a certificate of lawfulness of existing use or development. The second point I'd make under this is we always have to remember that in order to use permitted development rights for change of use, the initial use must actually have been instituted. And it's not just enough to have the planning permission. And there was a Court of Appeal case back in 1980, the Quick Save case, which we always refer back to when people inevitably ask, well, yeah, how long do I need to use the space for the initial use before I can take advantage of the permitted development right? And the answer is always to be fairly cautious. In that case, the benefits of the change, that related to a change within a use class of the use classes order. It was held that 4 weeks was not enough, where permission had been granted for a car showroom, and then the premises were to be used as a supermarket, and to use the space for 4 weeks wasn't enough to rely on the precursor of A1. And the same, in my view, would apply to using class MA. So you really need to be looking at several months worth of use rather than anything that could be said to be de minimis. My second main point is about which goes to the strategy of whether you rely on your existing permitted development rights, where applications for prior approval can be made before 1st of August, or whether you wait to rely on the new permitted development rights. And stating the obvious, that really is a case of looking at the various ways in which the new rights are more restrictive or may place additional hurdles. So if you're concerned about the new scale restriction, if you're concerned about the vacancy requirements, the need to provide a little more detail in terms of a floor plan with the floor space within each dwelling, if you're concerned about serving notices on neighbours, if you're concerned about this issue of change of use of the ground floor in a conservation area, then you need to think about making an application for prior approval under the existing GPDO before the 1st of August. My third point goes to what Zack was mentioning, which is how best to the frequent need to achieve planning permission for physical works alongside the use of the permitted development right. And it's really frustrating, to be honest, that there's no government guidance that perhaps suggests that local authorities shouldn't use the need for a planning permission in order to frustrate what could be achieved by way of permitted development rights. But we are where we are. In my view, it's best always to have the position where you've got a fallback of being able to show that you can carry out the change of use without the need for the external works, possibly even first to obtain prior approval on that basis, so that you can say to the authority, look, this building can be converted to residential development. It can be done with external works that make it more acceptable or not, but you cannot use the need for planning permission for external works as a way to frustrate the change of use, or by the back door to seek to achieve what you couldn't achieve by way of the permitted development procedure. And when you make the application for planning permission, be careful about things like the red line and how you express what you're applying for, so that it cannot be taken to be an application for planning permission for the change of use itself. There are complications, particularly with the new, with the latest prior approval requirements, such as the need to show that there will be adequate daylight, because if you need physical works to the external appearance of the building in order to provide the fenestration, so how do you deal with that? It's going to change. It's going to depend on the particular building, but in some circumstances, you know, you might think about making your application for planning permission for the external works to create the openings before you make your application for prior approval, to make it on the basis of the existing use. Alternatively, you may be driven to make both applications at the same time and make it clear to the authority how the two interact. But it's in some cases it's not going to be straightforward. So a couple more points I wanted to make. First of all, turning to Article 4 directions, and there's a few things on this. Now, we know that existing Article 4 directions in relation to office to residential permitted development right are going to be rolled forward automatically to the 1st of August next year. We also know that from the draft changes to the NPPF that the government is opposed to blanket unjustified Article 4 directions. And we know that rights to compensation arise if an Article 4 direction is expressed to come into effect earlier than a year after it's made. And that leads to, you know, four things. First of all, there's a window in relation to new permitted development rights that are not subject to Article 4 directions, because it's going to take authorities at least a year to have Article 4 directions in place. Article 4 directions that currently restrict changes of use other than office to residential are not automatically being rolled forward. So if there are permitted development, if there are Article 4 directions restricting, for example, retail to residential at the moment, they are not automatically being rolled forward. Thirdly, local authorities are going to need to make haste to make new office to residential Article 4 directions before 1st of August this year, if they're going to come into force by 1st of August next year without compensation implications. So, you know, there could be a window after 1st of August 2022, if authorities haven't made those directions before 1st of August this year. And then finally, of course, all new Article 4 directions are going to need to be tested against whatever the final wording in the amended NPPF turns out to be. But, you know, the wording at the moment that's proposed is pretty rigorous, because they're consulting over a choice of wording, either that where Article 4 directions relate to change of use to residential, they should be limited to situations where this is essential to avoid wholly unacceptable adverse impacts. There's quite a lot of subjectivity in that. Or as an alternative, they should be limited to situations where this is necessary in order to protect an interest of national significance, which really is quite a high hurdle, and again, subjective. In all cases, it should apply to the smallest geographical area possible. So how tough is the government going to be, and how interventionist in relation to future Article 4 directions? The final strategic sort of point I wanted to make was just quickly as to the potential effect of the new permitted development right, even if you do not propose actually to convert your building to residential, because that the existence of the right will obviously often have an effect on the valuation of the property, because it gives rise to, there's now a potential for change of use without the need for planning permission, and it will have and two other things. First of all, it is likely to have an effect on the benchmark land value of the property when you come to viability appraisals, because if you're proposing another form of development and you could use permitted development rights to convert the building to residential, then clearly that gives an alternative use value to feed into the BLV. And lastly, of course, it provides a fallback position to argue. And one of the questions that was raised beforehand was about, out of town commercial floor space, where a developer might argue, in the context of wanting to convert that building or that space to something which needs planning permission, but would be unattractive from a sequential test point of view. The developer could easily say to the authority, well, I could convert all this to residential under PD rights. That's the baseline against which you measure sustainability. So those are, the points I just wanted to raise from a perspective of advising potential users of these permitted development rights. I hope that's helpful.
Brilliant. Thanks, Simon. Sorry, I think I was almost stuck on mute for a minute. What a loss that would have been to the session. We've been through the nuts and bolts. We've covered the main subject matter. We've talked about various issues. We've talked about strategies. So we're going to move on to try and address some questions that we've had in a moment. I thought perhaps what might be a good idea is if we just have a quick pause here, just for a few minutes, to reflect really, I think, on the impact that Class MA might have really, in particular on high streets going forward. We're lawyers. This session is meant to be about, the law. It's very legally focused, but ultimately I think it's impossible to be blind to the fact that the response to the consultation on Class MA was overwhelmingly negative. It is clear that MHCLG has listened, and you can see that reflected in the form of the actual PD right that's now emerged. But really, is the net effect of something like this, with or without, the other PD rights that we saw come out last year, likely to have anything like the positive impact that the government headlines would suggest? So they've made some, some good mileage out of the headlines. But when we, take a step back, look at things like the significant conditionality, the long list of matters requiring prior approval, the sorts of things that Zack's just talked about. And that's really quite significant when we think about, the other limitations, particularly on size, the simultaneous scaling back of the office to resi PDR, which, seems to, the assumption is this must go hand in hand with this new Class MA. How many dwellings are we really going to produce here? And then I think when you set this next to the impact that this could have on high streets, ultimately the justification for the new Class MA, it's been set out as being making effective use of existing commercial buildings, especially where there's a surplus of retail floor space. It's going to bring in additional footfall, assist in wider regeneration of town centres and brownfield sites. I mean, those are some quite big claims, I think, particularly when you put that in the context of all that you've just heard. So as many commentators pointed out, it could have a really negative impact on some high streets, where the effect could actually be to dilute the offer that there is, to give us fragmented high streets that aren't coherent. So it could have the opposite effect and reduce footfall, quite considerably, I think, in some cases, although, fair enough, we don't know yet. And then there are other issues about needing to, increase conflict between certain uses, which are really not naturally good bedfellows anyway. I think the problem is that a PDR like this could have negative impact in a number of ways at a time when it really matters, given the precariousness of some high streets due to COVID. And more importantly, I think those impacts can be really different depending on where you are. But the problem with well, I suppose the problem with all PD rights really is, in essence, what you have is a one-size-fits-all approach that's trying to address a problem that does not manifest itself in the same way, across the entire country. So I think, well, I suppose that's me just sort of setting out my views on Class MA, and I think some of the problems behind the thinking. I don't know, Simon, Victoria, Zack, if you wanted to throw your hat in and go beyond the legal as to what you think about Class MA.
Can I just very briefly say, I do think, I'll get shot for this, I think some people are protesting too much. You can already convert shops of up to 150 square meters to residential using permitted development right. How many have we seen in high streets? I question whether these new use rights are going to be particularly attractive to the market. I think they were more attractive when they could deliver much larger scale conversions analogous to the old office to resi. So I think they're all very fiddly, and they're going to cause a lot of noise, probably a lot of pain for local authorities. They're going to cause a lot of distraction to developers who are looking whether they're providing a solution to a particular issue before they realize actually they're not that much better than a planning application. But as you say, we're only lawyers. Let's see how it pans out.
I think there's an enormous degree of uncertainty as to how this is actually going to pan out. It is a significant deregulatory step for all the watering down from the consultation version when you combine Class E with Class MA, and it's a big change in direction from governments over decades, not just a few years but decades, as to how they've approached planning in town centres. But all of that said, my overriding sense is actually to agree with Simon that I'm not convinced yet that it's actually going to be attractive enough to enough developers to actually, number one, deliver anything like the kind of chunky number of homes that the government are hoping for and that are relying on it in order to deliver. And number two, actually are going to, have those sort of, major impacts on the vitality or viability of our town centres. There are clearly really important, policy tools that others will be talking about in order to regenerate our town centres. I'm not sure one way or another this is it, but my overriding sense is that we don't know. I also think, just final thought on this, I agree with what Simon said, that you will find, I suspect, if you're interested in availing yourself of Class MA rights, you will find, after you look into the various quiddities and difficulties over actually trying to secure prior approval for Class A, you will start asking yourself, shouldn't we just put in a planning application and just deal with this all at once, deal with the physical changes that we need, and all of that. And that when in the end, it's going to come down very often to negotiations over affordable housing, which is not something that we've gone into yet so far. But anyway, that's about as non-legal as I'm going to go.
Okay, great. Victoria, did you want to?
Yeah, just a couple of thoughts from me. Largely, I was going to start with what Zack said actually, which was, I think most developers, in light of all of the conditionality and the restrictions associated with this, and the fact that it doesn't allow a right to carry out associated operational development, might be tempted just to avoid it altogether and submit a planning application. I think the combined effect of Class E and Class MA is significant deregulation, and I sympathise with the ambition of it. We need more homes, and if there are vacant commercial uses which can readily be made into homes, then that could be a useful outlet for their creation. Indeed, it's been successful, well, a mixed bag in terms of success, I suppose, for office to residential, high volume, but arguably lack of quality. Can this step into the shoes of Class O and Class M in a more managed, controlled way? Potentially, or has too much been taken out of it through the consultation process to make it really valuable and to really make a contribution to more housing delivery?
Thanks, Victoria. Yeah, I mean, I do agree. I can't really see it sort of resulting in a big sort of step change or uplift in housing numbers. I think, though, you know, just going back to something that Simon said earlier, I think it was Simon. Even if you do put in a new, full planning application to wrap it all up, you've in the background your fallback, and the thing that you can point to is this new PDR. So, that will kind of help. So in a way, it will have indirect effects as well, I suspect. I did promise that we would move on to some questions. And so, Zack, can I turn to you first of all with a question that I think Rachel Morgan has put in the Q&A, which is about considering relevant parts of the NPPF and whether there's a need to consider heritage impact, and she's mentioned the substantial less than substantial harm distinction.
I think this is such a good question. It's a real head scratcher, because my starting point is I am certain that those who promulgated Class MA, who actually wrote it, would not have wanted, applicants to have to get into a full scale heritage impact assessment on, assessing the scale of harm to setting or to the significance of your conservation area wherever you are, because then we really are, then you're starting to ask us the question, why aren't we just doing a planning application if we're going to have to do all of this very detailed work? But I think there is an argument, and we'll have to just see how this plays out. There is an argument that actually, yes, if you are in this situation where you're in a conservation area, you're redeveloping the ground floor of a conservation area, and there's this discussion to be had, which is the discussion that I alluded to earlier on about whether or not your scheme is impacting the character or the sustainability of that conservation area. Paragraph W, as I've alluded to earlier on, tells us that the NPPF is in play to the extent it's material to that issue. And where do we look for the bits in the NPPF which are material to that issue? We look in the heritage chapter of the framework, and then we are into, just as the question are, we're into issues of less than substantial and substantial harm being weighed against public benefits, indeed, which is not what a prior approval application is supposed to be looking at all, which is why I say I suspect it was well outside the contemplation of those who drafted Class MA. But it is a very good example of just the kind of uncertainty that we are going to face. This is not going to be theoretical. It's going to start happening as soon as people start putting in these prior approval applications. It will lead to refusals, and then we're going to, then we will find out after that, when those refusals start getting litigated, what the right answer is. But a really interesting point and a serious risk.
Thanks, Zack. Victoria, can I turn to you for some questions that have come in from David Whittington at Savills, which are really around the around timing and Class O. So the continued right to submit under Class O is up until the 31st of July. So I think there are questions around whether you can expect the LPA to determine under Class O rather than Class MA post the end of July. The situation with appeals made before the 31st of July, and generally how will those be treated after that date?
Yeah, thanks, Meeta. That's a technical one. So looking at what the amendment order itself says, so in respect of Class O, the developer must apply for prior approval on or before the 31st of July 2021. And in respect of Class M, where the proposed development includes a change of use from building in Class A1 or A2, the developer must apply for prior approval on or before the 31st of July 2021. So the deadline is the same. And it's notable that the legislation is specifically referable to the time limit in the legislation is specifically referable to making the application, not having it determined. So after the 31st of July, any new prior approval applications would need to be made under Class MA. And I think that accords with the transitional arrangements under the use classes amendment regulations, which introduced Class E last year, because they provided that the existing PD rights, which referred to the old use classes, should continue to be read in that way and hence have effect until the 31st of July 2021. So given the wording of the amendment order, my view is that is subject to the proviso that any pending applications or appeals can continue to be determined by reference to Class O or Class M as long as the applications were submitted by that date. And I think it's quite interesting actually to look at the class PA that I mentioned earlier, which has now reached its conclusion, which was the premises of light industrial to dwelling houses, because that was subject to a condition that development is not permitted if the prior approval date falls on or after the 1st of October 2020. So that's expressed quite differently, talking about when the prior approval date occurred and not allowing development post that, whereas this is specifically talking about the date by which the developer must apply for prior approval. And I think the explanatory memorandum also supports that, because it's talking about the purpose of the amendments being to prevent applications for prior approval under classes O and M being made after the 31st of July. I hope that addresses the question.
Brilliant, thanks, Victoria. Nationally described space standards, can we just hit that one really quickly, because a number of people have asked about that. Zach, shall I go back to you for that one?
Well, thanks so much. Okay, right. Nationally, at the moment, of course, we know those space standards are outside the permitted development rights for a moment. In general, they are optional space standards which can or can't be adopted on an LPA by LPA basis by, through the statutory development plan. So, some councils have policies that introduce and rely on national space standards, and some don't. And there are cases on appeal where, councils who seek to rely on those space standards, if they've not got policies to do it, they can be vulnerable to cost applications, because you need a policy basis for seeking national space standards if that's what you're going to be relying on. Anyway, that's the position outside the PDR. But I mentioned that because, by contrast, as Victoria mentioned, within the world of the permitted development rights, and if you're seeking your class MA, you are going to be addressing the national space standards. Now, what that means, the reason for drawing that distinction, is that may well end up being another reason not to do it at all, because you may find, who knows, it depends on which authority you're in, but you may actually find that it's a much more attractive proposition proceeding under the under a full planning application, where it's actually, ironically, maybe less onerous in terms of the space standards that you've got to meet, because it might only be if you go in under the PDR, under a prior approval application, that you're having to address these national space standards. But just to be clear, they do apply. You do have to meet them in the event that you're trying to avail yourself of a class MA.
Great, thank you, Zach. Simon, I'm going to turn to you for a question on operational development, which has come through from Pegasus Group. I suppose what the question is asking is, could local authorities be tempted to use the operational development side of things as a way to refuse permission? So, for example, if you've got the requirement about adequate natural light to all habitable rooms, you need to get windows. So it all gets a bit chicken and egg. But is that a potential route, I suppose, for local authorities to frustrate the ability to take advantage of Class MA?
Yeah, we've seen skirmishes, already over recent years in relation to office to residential, and attempts by authorities to most frequently, not in my experience, not to frustrate the idea of, for example, recladding the building to make it more appropriate for residential use, but to seek to use that as an argument for saying that there should be a contribution towards affordable housing, or something else to make, in their perception, the residential conversion more acceptable. And as I said, the unfortunate thing is there isn't government guidance on it in the NPPF or PPG. There isn't any relevant local plan policy that assists in most of these cases, and so you are driven to fallback arguments as to what the position would be if they did not approve the application for planning permission for the external works. So this may give right, maybe a wider planning principle at play in terms of if you have an application for planning permission where the works themselves applied for in themselves are potentially acceptable, but they may unlock the possibility of something else happening which the authority considers is unacceptable, then in my view it's only in limited circumstances that an inspector on appeal would regard that as an appropriate reason for refusal. And I'm looking at Zack nodding, and that's giving me comfort.
I quite agree.
Excellent. Looking at the time, we have well, we're 1 minute over at the moment. So I think at this point, this is definitely a good place to wind up the session. I'm sorry we haven't managed to cover more questions, but hopefully we have managed to cover enough during the questions and the actual panel pieces to give you the impression that we've definitely turned things around and upside down, and some of the issues that have been taxing you have hopefully been made a lot clearer. Clearly lots of questions and issues to come, however, as we start to see this work its way through the system, but that's obviously for another day. Now it's just wine o'clock. Thank you so much to the panel, and thank you so much to you for joining us, and hopefully see you at our next webinar in due course.
Thanks a lot. Thanks, Meeta.
Thank you.
Bye.
Bye.